Good morning, all. Today I am taking a lecture on concern. In today's lecture, uh, just I want to give the introduction. What are the principle of consent and what are the difference between the autonomy and some other things which I will include in this today's lectures. Okay, so today's lecture in this the content of all this lecture is about the concern is uh, introduction, the purpose of consent, what is informed consent from the form, and what is history, what is basic principles and elements of informed consent, and what could be the documents, and top 10 consent audit findings and summary that we will discuss in the today's lectures. Okay, so okay. About the introduction, millions of the voluntary participate in the government and the industries sponsored clinical trial in each and every years. So prior to agreeing to participate, every voluntary has a right to know what is going on, what the things which on which purpose their sample, their body and their material is using. So the consent form is required. So understand what during the clinical trial, and this is called an informed consent, and this process that helps to decide whether or not participating in the trial is right for you. So what is a consent? What is the purpose for that? The prospective subject, that is well, that is understand the nature of research, the sample or the things in which they are involved, their consent is required. So be informed of purpose, risk, benefits and alternative therapies, and make the voluntary decision about the participation. So in the another word, we can say that the consent refers to the provision of approval or agreement, particularly and especially after thoughtful consideration and understanding. As per the juris prior provision of consent signifies a possible defense, that is justification against the civil and criminal liability by the doctor. So the practitioners who use this defense claim that they should not be held liable for the tort of the crime. As consequence is the questions occurred with prior consent and permission of the patient without realizing whether it is commission or is omission and extend to the negligence. So what is medical consent? Consent is one of the critical issue in the area of medical treatment. The earliest expression of this fundamental principle, that is based of autonomy, that is found in the Nuremberg Code in 1947. That is, Nuremberg Code was adopted immediately after the World War II in the response of medical and experiment autocracies and committees by the German Nazi regime. The code makes it mandatory to obtain voluntary and informed consent of the human subject. So the defining the informed consent, that is defined by the ICH or GCP, in which a process by which the subject voluntarily confirmed his or her willingness to participate in the particular trial after having informed all aspects of the trial that are relevant to the subject decision to participate. Okay, and you can say in another word that informed consent is documented by the means of written, signed and dated informed consent form. Similarly, the declaration of the Helsinki adopted by the World Medical Association in 1964 emphasizes the importance of obtaining the freely giving informed consent for the medical research. That is, Medical Council of India has laid down the guideline that are issued as a regulation in which consent is required to be taken in the writing before the performing an operation. Nowadays, this MCI is changed into the national NMI, that that is a National Council of India, and this MCI guidelines are appreciable to operations and not covered to extend other the treatment or the procedure. These are covered under the implies and express consent. So the medical consent, that consent is perhaps the only principle that runs through all aspects of the healthcare provision today. It also represents the legal, ethical expressions of the basic right to have one autonomy or self-determination. If the medical practitioner attempts to treat a personal or a person or the patient without valid consent, then he will liable under the both tort and criminal law. The patient must give the valid consent before medical treatment, and is prerogative to refuse the treatment even if the said treatment will save his or her life. Now, what is informed consent? The informed consent is a communication process between the patient, researcher, and participant, and then starts before the research is initiated. The continuous throughout the duration of the study and the duration of the treatment, that providing all relevant information to the voluntary or to the patient, and the patient and the voluntary understands the informed provided voluntary agreement to the participant, a basic right. So now in case of law and medical consent, the right autonomy of the patient have a deeply eroded the model, the old model of the doctor patient relationship. Doctors are no more gods. There have been significant changes in the doctor patient relationship with the advancement of the technology in the day to day practices. So, more and more patients are becoming aware their rights and are keen to make free choice and decision of their treatment. This helps them to choose the treatment of their choice from the option available and to select the physician of their choice. Now, what is informed consent? As I discuss here, that informed consent that we are discussing here is that informed consent was the practically not existent till the time COPRA, that means Consumer Protection Act, came into the existence. This is seen as more as legal requirement than an ethical moral obligation on the part of doctor towards his patient. The patient has now ability to select or dismiss their doctor and to choose the treatment of their choice from the option available. And the important aspect of the several medical consumer uh, litigation is important concern. Now, consent in the medical practice that exists a duly obtained prior consent with respect to the living patients for a purpose of diagnosis, treatment, organ transplant, research purpose, disclosure of the medical records, and teaching and medical legal purpose. With respect to the dead, with regards to the pathological autopsy, organ transplant, for legal and for the disclosure of the medical record, it is important that prior informed consent of the patient or relative is obtained after the death. Now, and the consent of consent and medical ethics, there is a good connection between the two. The Hippocratic oath that prevalent for the centuries have been granted the doctors to the right to decide best interact with the patient, but the same has been conflict with the trends of the 20th century right of, that is a freedom to control the health as well as avoiding non consensual medical treatment. The clinical ethics teaches physicians a wide range of specific ethical issues that is informed consent, truth telling, end of the life decision, advanced directives, that is subjective decision making to incomplete patients, and emergency consent. So what kind of the consent? The type of consent could be the informed consent, express consent, implied consent, then surrogate consent, then advanced consent. So what is informed consent? It is defined as a voluntary acceptance after the full understanding by the com, uh, competent patient of a plan of medical care after the physician adequately discloses the proposed plan, its risk and its benefit also, and alternative approaches also. The decision making capacity is free from the concerns or manipulation by the patient or the doctor. And what are the components? The informed consent must contain four vital components: the mental capacity of the patient to enter into the contract. This is also includes his ability to understand information given, and complete information to be provided by the doctor, and voluntary acceptance of the procedure by the patient should be person and the procedure specifically. And content of the consent, that is condition, that is disease of the patient, purpose and nature of the intervention, and consequences of such intervention, any alternative available, and risk involved, the prognosis in the absence of intervention, the immediate and uh, future cost. The knowledge regarding the intervention should be an understandable language and format so that decision in form of authentications by the patient can be made. Now, what is the eligibility for the consent? The eligibility of the consent is the age, soundness of the mind, ability to understand, remember the information given, the ability to deliberate and decide the treatment choice, and beliefs that the information applies to be said, patient, and specific purpose. Now, what is express consent? That could be the oral or in the writing. To both these categories of the consents are of equal value. Written consent can be considered as an superior because of its evidential values, and oral consent should be taken in the presence of understanding third party, and it could be the uninterested third party, mainly in cases where the intimate examination of the female is required. The test necessitates the removal of the body fluids. The radiological examinations can be done after the securing oral consent. Okay. And where is the written consent? It is advisable to take the written consent in the presence of the disinterested third party. This is called the third party is only to attest the signature of the patient, and consent should be taken in the patient's own language. Written consent is mandatory in every invasive diagnostic or therapeutic procedures or any medical legal examinations. Now, next is a implied consent. The implied consent may be implied by the patient's conduct. So, it is basically the conduct of the patient when he comes to the doctor for the examination and the treatment. The doctor should remember that this is only for the routine examination as well as treatment. This does not extend to perform of intimate the examination or diagnostic procedure. If there is a slightest chance to any complication expression, consent should be taken. The tactic consent. Fourth one is called the tactic consent. The tactic consent means the implied consent understood without being stated. Usually, the way patient presented himself for the treatment imply consent. Now, fifth one is called as surrogate consent. This consent is given by the family member for the minors or dead, or generally the court have uh, held a consent of the family member with a written approval of the two physicians sufficiently that protects the patient's interest. And next is the advance consent, that is this type of consent given by the patient in advance before death. And proxy consent, that it indicates the consent given by the authorized person before and after the death. If any unconscious patient brought by the police from the road and the operation essential to save the life, 2 or 3 doctors to give the consent by the signing on consent form, preferably along with police. Informed consent obtained after the explaining all possible risks and side effects is superior to all other form of the consent and legally defensive. What could be the consent format that I will show in last of the lecture. That consent format is I will show at the last of this lecture. What could be it? That is signature of the concernee and signature of the doctor. Now, who can give the consent? The simple medical examination, the minimum age of the consent is 12 years. The consenting to have any major diagnostic or therapeutic procedure of the surgery, the age is above 18 years, that IPC section 87 and 93. The patient should be mentally sound and he or she should not be under any fear or threat or any false conceptions. The patient should not be intoxicated or sedated. The incomplete information about the patient diagnostic, therapeutic plans, etc. A commission that misconception of the omission. So, what is the consent required? Consent requires somebody else other than the patient wants him to be medically examined and medically certified to be issued or by the employee, and the consent of the concerned person must be obtained, otherwise the doctor runs the risk of liability to pay the damage, such as issuing the certificate that involving the complicated process of examination of the infertility in the women's, or when the process is likely to affect the physician, that is physical or mental well-being of the patient, that is financially loss and damage to the reputation, that is social status, that is STD diseases and HIV diseases, or procedure voluntary rights of a spouse in case such as sterilization, artificial insemination. Even after the consent is taken, the examination should be done in the presence of third person, that may be the nurse, female attendant, while examining the female patient. Now, before we will move forward, so we should have some idea about the histological background is informed consent. Okay, so in 1891, the Prussian minister, the tuberculin for the treatment of tuberculosis must not be used against the person will. In 1898, Dr. Albert Neisser was fined for the Royal Disciplinary Court for not speaking patient consent from the experimental studies of the vaccination for syphilis. And 1907, Sir William Olsker, that is also endorsed necessary to inform the consent of medical research. 1931, Health Department regulation of the German Rechtsystem, that for the human experimentation and use of novel treatment required consent is clear and unbeatable manner. And in 1945 and to 1966, NIH funded 2000 research products, none of them use informed consent, that birth defects is found. World War II and unethical clinical trials done by the US Health Services that given birth to the bioethics and um, creation of the IRB and notices to inform the consent. And the National Research Act, that is of 1960 and 70, the National Commission for the Protection of the Research Participant in the Biomedical and Behavior Research, and 1979, that is of Balmont Report. So, what is Balmont report? Balmont report is the expanded and definition of the informed consent. The participant keep informed throughout the experiment or the treatment, understand the risk and benefit, and protection of the vulnerable groups. So, you can see that federal regulation, institution at the policy, ICH good clinical practice guideline, and sponsor request. Now, what is the basic principle for that? That is of autonomy and second one is called as beneficence, and third one is called the justice. Now, what is the element that is informed the consent form? The protocol number, the name of the student that I mentioned previously, what could be the form, the purpose of the study or the treatment, the duration of the study and subject involvement, and the statement that protocol and the informed consents were reviewed within a participation that include the risk and benefit of the study and the treatment and alternative treatment option discussed and confidentiality record, no subject, compensation for the injury, time of the question to be asked and answered, description of the participant decision, contact details, travel reimbursement, subject responsibility, subject satisfaction, used understandable languages, copy of the consent was given to the participant or the patient, and signed copy of ICF is also be there. Now, before we will forward to the research work, first we will finish up about the medical, then we will switch to the uh, research purpose. So the exception to the informed consent, that is about in the medical treatment, that is a doctrine to the therapeutic procedure, that is a certain procedure detail, especially invasive tests for the complicated surgery may be difficult to explain to the patient. The often patients themselves do not want to know about it. It is better to explain to the family members. Okay. Now, doctrine of the emergency. Under the section of 92 of the Indian Penal Code (IPC), treating without consent of the patient is permissible if the patient is unconscious, mentally ill, or gravely sick, and no attention with the patient. No attendant will be with the patients. So it is implies that the procedure surgery is done to save the life or the limb of the patient, and if possible, surrogate and proxy consent should be taken. And doctrine of loco patient, that is in the children in the emergency, when the parents, guardians are not available, consent can be obtained from the person bringing to the child school teacher. Now, exceptions to be informed consent, that is of incompetence. The incompetence patients such as delirious, unconscious, sensile, psychotic nature, etc., are unable to make the rational decision. In these cases, they can be treated without informed consent involving the emergency doctrine. The therapeutic privilege, if the doctor suspects that passing full information could have detrimental effects on the health of the patient, then he need no follow. Doctrine of full disclosure and can be excuse of obtaining the consent from the patient. However, to take the privilege of the doctrine, it should be disclose full information to the complete relevant of the patient. Now, what is of full disclosure? The full disclosure, the doctor is legally bound to pass on every detail regarding the disease condition, nature of the proposed treatment, any alternative treatment, and prognosis with possible risk and benefits of the procedure to the patient. The mental capacity, physical condition, as well as the age of the patient should be considered while the delivering this information, and likely after effects, or else the same information can be passed on to any other authorized person. This therapeutic privilege of the doctor is an exception to professional secrecy. The consent is not required where the medico legal cases brought by the police. The consent is applies under the section 53 of the Criminal Procedure Code, hence can be examined. Second, the consent is not required in the medical examination and issue of the certificate for the insurance policies. Third, the case where it is issues in the interest of community. Fourth, a person suffering from the disease under the notified categories, that could be the to notify the authorities only. or next is prisoners, that means new enters, and next is examination under the court order. Next is request by the police officer under the criminal PC section 53(1). To avoid insufficient legal interpretation, informed consent should be understood in the term of autonomy. The continuous interaction between the patient and the given physician is considered as an essential prerequisite for realization of the standard of IC, that is informed consent. Now, what is the difficulty in the obtaining consent? The difficulty that is in getting the informed consent, that includes the um, incompetence and mental capability of the patients. Okay, and unusual socio-religious beliefs of the patient. Next, extent of truthful disclosure. Next, incompetence of informed disclosures. Next, advanced directives by the terminally ill patients or those who anticipated grave illness. Next, durability of the power of attorney for the health care when the holder gives the consent and decision in the advance. Wow. What is Indian legal provision? The Indian legal provision section 53 1 CRPC, in the criminal cases when the examination of an arrested person can lead to the vital evidence related with the commission of the crime, he can be examined by the doctor without his consent and even using the force if the application for the examination from the person not below the rank of sub inspector. Okay. Next is section 54 CRPC. An arrested person can also request to examine by the doctor to detect any evidence which he feels are good for him. Next, section 87 IPC. The person about 18-year age can give consent to the suffering any harms if the act is not intended and not known to cause the death or grievous hurt. Next, section 89 IPC. A child under the 12 year of the age or a person of under sound mind cannot give the consent to suffer any harm for an act which may cause grievous hurt or the death, even if done in the good faith, but the consent has to be obtained from the guardians of the child or insane person. So, in consent is very much required in all the patient and medico legal cases. Before treatment, before taking trial, the concerns are very much required before proceeding. Okay, if this is about the medical concern where it is, and simultaneously same concern is also required for the study of the patient sample, patient material, and the um, jurisdiction of the patient's area. In all the aspect, for all the things, the, the, the concern is required of the person or the patient or any person on which or from which we are taking the sample or on the which we are doing the study for trial, for the vaccine preparation, and for the study purpose, for the medicinal effect, if you want to, or if they are willingly participate in the trial. So all the concerns are very much required for these. Mainly the concern that is of different type of concern, that is informed concern, express concern, implied concern, surrogate concern, advanced concern. According to the need, all other different type of concerns are required. But in all this, The written consent is very much important and good, uh, because that can be this type of consent we can make the record and preserve it for the further disputes. So information should be include the information consent form. So we will go through it. Why the research is being done, what are the researcher help to accomplish, and a description of what will be done during the study, how long you are expecting to participate, the risk of the person or the patient from the participation in the study, and what will be the benefits after the participation of the study or the treatment, or other treatments are available if the person or patient is decided not to participate in the study. Verification that they have right to leave the study or at any time or the treatment anytime, and they stay in medically care will provided without penalty if choose withdraw from the study or the trial. Although the informed consent document must be signed before the enrollment of the study, it is important to remember that informed consent is process that continuously throughout the study, and they may ask questions of the healthcare provided anytime before, during, and after study. In informed consent form, that is readability, language that easily understood, language must be appropriate, or uh, pop, populations being studied, the language translation should be qualified and IRB authorized. Okay, so the considerable compensation as well as readability limits the medical terminology, avoid the informal speech. So this is all about the today's lecture, in which we have included what is consent, what is consent forms, what are the type of consent, and what is the use of consent, and what are the consent form, and why it is essential and necessary. So thank you very much for being with me. Have a good day.